The Court of Appeal in the 4th District of the State of Florida is now in session. The Honorable Lindsay Palmer, Judge presiding. All persons having business before this court draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and its honorable court.
You may be seated. Good morning and welcome to an oral argument session. Let me begin by introducing the panel. As you've already heard, I'm Judge Palmer. To my right is Judge Sawaya. To my left is Judge Monaco. We have 3 cases on the docket today. They're all civil cases. Each side will have 20 minutes. The appellant can reserve as much of their time for rebuttal as they choose. We will take a break after the first 2 cases, and we'll invite the lawyers to join us in the Lawyers' Lounge for coffee if they'd like to join us. First case on the docket is Chiropractic 1 versus State Farm.
May it please the court, counsel. My name is Sylvia Gruner, and I represent Chiropractic 1 in this litigation and also in this appeal. The brief was co-written by Amy Romaine. This is a case involving PIP, or personal injury protection benefits. It arose individually at the beginning with PIP suits that were filed in the county court in Orange County, the 9th Circuit in Orlando, and also in the 18th Circuit of Seminole County. Thereafter, State Farm, its general entity on behalf of multiple State Farm entities, filed a declaratory judgment action in the 9th Judicial Circuit in Circuit Court.
Is there really any issue as to whether there were fraudulent bills that were submitted? I mean, is that even an issue?
No,
the issue is whether the PIP carrier has the right to deny all benefits for the claim when some bills have been fraudulently submitted for payment, right?
You're absolutely correct, Judge. The PIP
what is a claim?
The PIP statute, Judge, and I beg your pardon, the claim is that there were benefits or treatment.
What is a claim? Is a claim, for example, if an accident happens and the person is injured and they go to a chiropractor for treatment, and then they go to another doctor for treatment, and they go to a third doctor for treatment, does the claim encompass all the treatment provided by all doctors, or does the claim provide treatment by individual medical care providers? How do you define the claim?
I define the claim as any treatment received by the insured by any medical care provider licensed under the statutes of Florida, whether it was by Chiropractic 1 or any other medical
Okay, so
provider.
you're saying that the claim encompasses all medical treatment that is necessary as a result of the accident?
Reasonable, related, and necessary under the statute.
All right, and so if the legislature says that the PIP carrier does not have to pay benefits to a person that submits a fraudulent claim, that means that that's it. If there are legitimate claims included with the fraudulent claims, everything goes out, right?
If under one portion of the statute, in the PIP statute, that is what it says. However, in this particular case, that's not what is at issue. What is at issue in this case are billing records of a particular provider, and the statute provides for the procedure of handling of those particular billing records. If you had, for instance, an insured who misrepresented their insurability, that's what would call into effect the entire claim. You were fraudulent in your application. You did not disclose somebody or whatever.
What if the medical care provider submitted one fraudulent claim or one fraudulent bill and submitted 20 others that were legitimate? According to your definition of claim, I mean, they would be all out. I mean, the PIP provider would not have to pay anything under that particular portion of the statute that you just referred to.
No, sir, and if the court understood that by my statement, I apologize.
That's why I asked you, what does a claim mean? What is a claim? And you said a claim encompasses all medical services provided by all medical care providers as a result of the accident.
It is, it's all-encompassing.
So?
It's all-encompassing. A claim is each and every treatment.
Well, let's assume that the chiropractors, and so by your definition of claim, I understood it to mean that if one bill was fraudulently submitted and 20 were legitimate, that the PIP carrier, because of the all-encompassing nature of the claim, the PIP carrier would be relieved from paying the legitimate claims as well.
And I apologize if I misspoke to the court. No, sir. A claim in this particular instance is each and every bill that's submitted on behalf of treatment rendered to an
That's a little bit
insured.
different than what you said before.
I beg your pardon, Judge.
Right.
You're absolutely correct. Each and every bill that's submitted in the Florida statutes has a provision and a procedure for handling those bills. If an insurance company believes that the bills have been either unbundled or bundled or fraudulently submitted, or there are CPT codes that were
What does the procedure have to do with the substance of the claim? If the substance of the claim is fraudulent, but they followed the proper procedure in getting the claim to the PIP carrier?
Because the statute outlines the procedure that an insurance company has to follow in investigating the claim.
Well, can you follow the procedure and submit a fraudulent claim anyway? The substance of the claim be fraudulent?
You can submit a claim that is later determined to be in part fraudulent, absolutely.
By that you mean there might be 8 or 9 different itemizations on a single bill, and some of them might be fraudulent and some might not.
If there is not sufficient evidence before the court to indicate that those billing procedures, those CPT codes that were included on the bill were not performed, and that by that it is fraudulent, then that part of the bill is out.
But just that part of it?
Just that part of the bill.
How is there a line that's drawn where the bill is so fraudulent to begin with? Let's say there's 20 itemizations on the bill and 19 of them don't meet the statutory requirements. I'm using the word fraud, but it might just simply be a failure to properly follow the statute. Suppose 19 of them are illegitimate. Can the carrier legitimately decline the entire bill?
No, Judge. Under the provisions of the PIP statute, the carrier has to follow sacrosanct 627-736. You have to follow the procedure for investigating the bills. If you don't have sufficient information in front of you to tell you that that is a claim or a treatment or a procedure that was lawfully rendered, or that it was not reasonable, was not related, or was not necessary under the statute itself, it says don't pay that CPT code bill. Don't pay it.
Don't pay the bill or don't pay a portion of the bill?
Don't pay that particular CPT code, unbundled or bundled. That is what that provision says.
So if the insurance company has evidence in front of it to show that 19 of the 20 charges are fraudulent, it still needs to pay the 20th charge?
Absolutely, Judge. Under the provisions of the PIP statute, it absolutely has to.
The statute says an insurer or insured is not required to pay a claim or charges. And then you go to see to any person who knowingly submits a false or misleading statement relating to the claim or charge. So, I mean, it depends on what do we mean by claim? Does the claim encompass all itemized charges in a bill, and does it refer to a number of bills that were submitted at different times by a medical care provider? What does it mean by claim? To me, that's the key here in trying to interpret what the statute means.
My understanding in looking at the statute, Judge, is because the statute is set out in two completely distinct parts. It tells the insurance company how it has to handle its bills. When you receive a bill from a medical care provider...
Yeah, but let's go back to what does this language mean? This language could easily be interpreted to mean that if you submit a bill and part of it's fraudulent and part of it's not, it seems to me that it could easily be interpreted, I think, in a reasonable manner to say that the PIP carrier doesn't have to pay anything then.
And I would suggest, with all due respect, Your Honor, if it could be so easily interpreted, we would have multiple cases in Florida law where it had been so interpreted.
Now,
We
counsel,
do not.
is the statute you're referring to 627.7367A?
That is my understanding is that's a statute that Judge Sueya is referring to, that a claim, if a claim is fraudulently submitted, then the insurance company is relieved of liability.
Well, the statute I'm referring to is 627.736 5B1C.
And
that statute says, and I'll repeat, it says, any insurer is not required to pay a claim or charges to any person who knowingly submits a false or misleading statement relating to the claim or charge.
And Judge, I would indicate to the court that under the case law interpreting this particular statute, and there are a legion of cases interpreting this particular statute, that statute has never been interpreted that way. It has never been held to say that...
Well, what case do you have that says that you pay the part that's legitimate and you don't pay the part that's fraudulent?
I have the statute. I have 5...
No, you're saying the cases. I mean, give me the cites of the cases that say that you only pay the part...
I can't prove a negative, Judge.
Well, no, you said that the cases are legion. So give me one cite that says... You said the cases are legion that have interpreted this statute and that they say that you only reject the part that's fraudulent and pay the part that's legitimate.
The United States Automobile Insurance Company versus Stat Technologies. It's found at 787 Southern 2nd 920. That is a 3rd District Court of Appeal where the district court held that the insurers are provided with a 30-day period to verify whether a loss is payable under PIP provisions of the policy or whether the claim is barred. And thus... Did you
even raise that argument below in the trial court? Was that an argument that was made?
Absolutely, Judge.
Did that case involve bills that were partially fraudulent and partially real?
No, Judge.
Do you have any cases that have addressed the issue we have here, which is a bill that contains fraudulent charges and non-fraudulent charges?
Not specifically fraudulent charges per se. What we do have are cases that have raised the specter under that provision of the statute where you have left, or a medical provider has left off a license number and therefore not completed a complete, or not made a complete statement, not given notice of a claim. And by not giving notice of a claim, does that get them out under that provision of the statute? And the answer is no.
Do you have any cases that deal with payment of part of a bill and not a part of a bill, separate and apart from whether it's fraudulent? If there's a coding problem, do you have any cases which say if the bill is in some way improper or incomplete, the insurance company still has the obligation to pay those portions of the bill that are complete, and they can refuse to pay the portions of the same bill that are incomplete, or do the case law says a bill is either complete or incomplete?
No, sir. The case law does not say a bill is either incomplete or complete.
Right.
Its case law says, and the statute says, that you interpret the statute by its own language. You can't piecemeal this statute.
All right. Do you have any cases that have piecemealed a bill?
No, Judge. I have no cases that have piecemealed a bill other than the case that's on appeal right now, this one.
Has the legislature addressed this issue since these statutes were adopted?
My understanding, Your Honor, is that there's and have been numerous bills proposed to the legislature to encompass this.
Adopted any?
Well, trying to draw this type of distinction within the PIP statute, but the statute has not been rewritten to include it. This statute has been in force and in effect since our Tort Reform Act. It has been rewritten, written over, analyzed, and absolutely decimated by case law. And as a result, the legislature goes back in every term and tries to rewrite it again. They keep trying to change the law so that the insurance company can change the way they administer claims. But what is absolutely in this claim is that from 2002, when the first accident happened, to 2005, when the last accident happened under the consolidated patients in this deck suit, State Farm, not only did they say, I'm looking at the claims that you've submitted, and I find them to be fraudulent, in part or in whole. They're saying, even what you haven't submitted, I'm not paying them. I'm not paying them at all, and I'm not paying
because they concluded that the claim itself was fraudulent.
Absolutely, Judge. They said
Do they
that...
have a right to do that if there is if 90% of the claims being submitted are clearly fraudulent?
No, Judge. There is no fraud in part.
You can't just simply reject the claim itself.
They can reject the claim if they give the medical provider a reason. If they tell the medical provider on this CPT code, it does not match this ICD-9 code, the treatment code. They can absolutely explain to the medical care provider what's wrong with your billing and reject it piecemeal.
Well, the PIP carrier can say, the code is wrong, this is the correct code, and we'll pay pursuant to that code and pay them, and then, they can fight it out later. And then if the medical care provider wants to reject it, they can reject the payment and say, no, we coded it right to begin with.
And that's exactly...
But let me ask you this. You're saying that it's really subparagraph 5B that you have to read in paramateria with the language that I quoted from 5B1C.
Yes, sir.
What if I say that they're separate? Or let's assume for the purposes of argument that we say 5D doesn't apply here. And so we're just looking at 5B1C.
And that 5D does not apply.
Right.
If you're indicating that 5D does not apply, then you're taking out your authority language, because it's the authority language that the insurance company in this case used to interpret its bills.
Well, let's just assume it says it's a fraudulent bill that they knowingly submitted a false or misleading statement. And I don't know that, that subparagraph 5D, necessarily covers that situation. But let's just take 5D out of the equation. And and you've already admitted to this court or submitted to this court that there's no issue as to whether there was fraud committed in this case. And there were false and misleading statements made in connection with the charges.
I've indicated that
so if some are fraudulent and some aren't, doesn't this B1C seem to indicate that the PIP carrier is relieved from paying any of it?
No, Judge. What I've indicated to this court and what I've indicated to the trial court below is that there were x-rays that were performed that when later examined, the x-rays were not in evidence. Years after the x-rays were performed, the x-rays could not be found. Using that as a bootstrap argument, State Farm said that since you presented a bill for an x-ray that we now cannot find, even though there is a reading of that x-ray, that's a fraudulent bill. So everything under that billing, everything under that particular, whether you call it a HCFA, Health Claims Administration form, or a CMS 1500, the billing form, whether you call it either one of those things, every one of those CPT code treatments cannot be paid according to State Farm.
Counsel, can I interrupt just a second? I want to talk about 4B1. It begins, an insurer or insured is not required to pay a claim or charges. Claim or charges. If you go down to any person who knowingly submits a false or misleading statement relating to the claim or charges.
Yes, sir.
What does that mean?
The way it's been interpreted in the case law to mean, Judge, is that if an insured has procured their insurance through misleading or misrepresentation either in their application, or let's say that they didn't misrepresent their application, they got a good insurance policy, but they set up
It
an
says
accident.
claim or charges, we're not talking.
And it says submits a false or misleading
Right.
statement.
That was my next part. If they had a set-up accident, it is not related to a legitimate motor vehicle accident. That's when that part of the statute comes into effect.
So if a chiropractor knowingly makes up a fraudulent bill and sends it to the insurance company, they are not a person who knowingly submits a false or misleading statement relating to the claim or charges?
If a chiropractor submits a false bill, first of all, would be a fact question.
Well, but assume that fact. Would they then be a person who knowingly submits a false or misleading statement relating to the claim or charges?
It depends on the type of statement that was found to be false or misleading, specifically. Because under the statute, which we are...
Well, what if the statement is a statement that contains 19 treatments that they just didn't do? They just made them up and put them on the bill.
Then the insurance company doesn't pay those 19 statements and pays the other one.
Well, but aren't they still a person who knowingly submits a false or misleading statement relating to the claim or charges?
If there has been a finding of
Okay,
fact...
but if there's been a finding, then they meet that definition of a person who knowingly submits a false or misleading statement, correct?
Yes, Judge.
And the statute says an insurer is not required to pay a claim or charges to any person who knowingly submits a false or misleading statement. So doesn't that statute say, under my hypothetical, that therefore the insurer is not required to pay that person?
Under your hypothetical, it could be said that way, but that your hypothetical is not this case. Your hypothetical does not include the CPT codes and the proof that we had in this case. The only evidence that State Farm presented was this deposition testimony of
Well,
the
you've already
medical
said there's
director.
no issue there were fraudulent statements. You, at the very beginning of this argument, you conceded that, so don't argue to us now the weakness of the evidence or whether or not there was fraud. You've already
And I
conceded
beg your
the
pardon,
fraud.
Judge, my statement was based on the fact of the x-rays. I believe, and I thought that I made that part clear. The x-rays were what started...
We're not relitigating today whether there was fraud or not, correct? One of your issues on appeal isn't find that there was no fraud.
One of my issues on appeal is that it's not an entire fraud, it's to the entire claim. State Farm said that there was an x-ray that was not produced, therefore that was fraud, as to the entire claim.
Okay, you're well over your time. Thank you.
Thank you, sir.
We may want to extend these an extra 5 minutes or so.
Okay. Well, I will give you 2 minutes for rebuttal and add 2 minutes to the other side's time.
Thank you, Judge.
Okay, please, the court.
Yes, it does. Counsel, what happens if there's a bill that contains 20 items and only one of them is fraudulent?
What happens then is you have to look at under your hypothetical, it's fraudulent, which means it was a knowingly made false and misleading statement. The claim is not due.
It's not due.
The entire claim is not due, and I'm prepared to explain what the claim is.
And that means that proper notice was not given to the insurance carrier because one item is, well, let's just say it's a coding error, an unbundled. I think in this case there was facial releases or whatever it was, myofascial releases and so forth, bundled with something else that they shouldn't have been. Suppose there's only one of those and all other treatments on it are legitimate.
Okay, let me answer that question and let me back up more generally. The filter for this, as to whether you lose the entire claim, which I'm prepared to explain, is the knowingly element. Okay, if you look at 5B1C, it has the knowingly element in there, and knowingly is defined. So taking your hypothetical, if it's a mere error, which we all know happens, and it's a mistake, and it's one out of multiple charges, nobody's going to determine that was done knowingly unless there's some sort of substantial evidence of fraudulent conduct. So in that case...
How is that determined in this case? How
was
is
that?
knowingly determined in this case?
By a tremendous amount of evidence that I'm prepared to go through if you want me to. The 97140 being double billed with the 98941. Mr. Talley, the State Farm representative, sent a letter to Dr. Bucko way back in December 2003 saying you can't do this, it's improper, and closing the AMA. They kept doing it. Dr. Bucko testified clearly in his deposition, it's in the brief and it's in the record. He said, I understand that chiropractic 1 cannot be paid for 97140 when it's performed to the same region of the body on the same date. I know that. However, we bill every time we do that, even if it's to the same region of the spine, we bill it and it's up to State Farm to figure out whether or not to pay it. That was his testimony. He knows it's wrong, but they billed it anyways. As far as the 97112 goes, they build it, that's neuromuscular re-education, they build it over and over and over again. Dr. Bucko said in his deposition testimony, said, I can't tell you what we did to support that charge. He kept doing it. Irma Howell, they submitted bills over and over again with no documentation for what they were billing for. She said in her examination under oath 3 times, that's a problem. For which I have no explanation.
I hear what you're saying. And
so I can go through the fraud. That's not a problem.
I guess the thing that's troubling and the thing that makes this case difficult is that these bright lines that we tend to set up always seem to cause a problem. And it's bothersome to me that we might determine that if you have a long and thorough treatment of a patient and one person decides for whatever reason to knowingly submit a single fraudulent claim, part of a claim, that the entire thing would be thrown out. That's bothersome to me.
Okay, well, let me address that. And your hypothetical was the person did it knowingly. It was intentionally done.
Yeah. There may be seven doctors involved in this one patient, and the one doctor decided they were going to cheat.
Oh, well, let me address that issue. I have a more narrow definition of claim than what Ms. Gruner explained to you at first.
Okay.
I think the claim in this case is all the bills submitted by Chiropractic 1. I do not think it bleeds over to some other legitimate doctor.
Oh, no. I'm talking about there were 2 doctors in Chiro 1 at treating this patient. Suppose one cheats and the other doesn't.
Okay, well, Chiropractic 1 is the entity that's billing. It's responsible for making sure the bills that go out are correct and not fraudulent. And if a fraudulent, your hypothetical is a knowingly false and misleading statement is made, the simple answer is don't do it. Don't knowingly make a false and misleading statement.
What happens in situations where you've got continuing treatment and there are continuing bills going out, and some of the bills have to do with a long list of medical care provided by that medical care provider? And let's assume that one of the bills is clearly fraudulent, but then 2 weeks later and 3 weeks later and 4 weeks later, these other bills come in and they are totally legitimate. But they are rendered and submitted by the same medical care provider. And they have to do with treatment of the same patient that was injured in the same accident. Are you saying that simply because the first bill may have been fraudulent, but all the others that were submitted at later dates for subsequent treatments are legitimate, that everything is wiped out by the fraud of the first claim?
By that provider. Within that provider's claim, no other provider. Yes, I am.
Okay, what part of the statute are you reading that suggests that?
5B1C. And
It
ensure...
says to any person who knowingly submits a false or misleading statement relating to the claim or charges.
Right. The person in this case is Chiropractic 1. If Chiropractic 1's first bill or second bill is fraudulent, we're dealing with that hypothetical, there's no doubt it's fraudulent, then the person is Chiropractic 1. Neither the insurer nor the insured, in this case State Farm, the insurer, has any duty to pay benefits or compensation.
It's the timing of the fraud then, because let's reverse it and let's say that they submit 5 bills for treatments, and all of them are legitimate, and then the last one that they submit is fraudulent. You're not going to claim that you can go back and get your money back for the benefits that you paid for the first 4 legitimate bills, are you?
Whether we'd have a claim for unjust enrichment to go do that, I haven't thought that one through.
I mean,
because that's not
What
an issue here today.
what if the first 4 bills are still pending and you haven't paid them yet because they're in process, and then the 5th bill comes in? Would you stop payment on the first 4?
And we're talking clear fraud, unquestionable on the 5th bill? I think the insurance company would have the right to do
Your position would
that.
be that that's it. But if you've already paid it, whether you're able to go back and get your money back, it would be something that you'd have to decide based on the economics of trying to.
Sure, in practicality.
Does that even make sense?
Well, it depends on the situation, I think, but this is real important. The one filter is knowingly, and all our hypotheticals are assumed, but here's the other filter. Neither the protection, neither the insurer nor the insured is responsible for the bills in this situation. So this is not a case where State Farm walks away and says, sorry, this was knowingly done, it was fraud, you're left hanging insured. The insured doesn't have to pay either. So the statute was built in with these protections, and it says to providers, don't do it. Don't knowingly submit a false and misleading statement. If you do, this is what happens.
Why do you reckon there's never been another case, despite the long history of the statute, on this point?
Well, this statute came in 2003. As we all know, most PIP cases, this was an exception because we went on the offensive here, most PIP cases are filed in county court, and it takes a long time to percolate up to the District Court of Appeal. That's why this case is so terribly important to State Farm and the insurance industry, because it's the first one to make it here. And to answer your question, there are no cases interpreting 5B1C at the District Court of Appeal.
About at the circuit level as an appeal from a county court case?
There is a new case out.
You said a supplemental authority on that.
Well, that was a county court case. There is also a circuit court case that cites Chiropractic 1 in Florida Law Supplement. I didn't attach it as notice of supplemental authority, but I can if you want to see it.
Yeah, would you please submit?
Yeah, it does. It doesn't really address the issues we're here on. It kind of addresses some collateral issues, but it cites this case below, and it says this was the holding, and that when it gets on remand, the court should consider this, and I will file that.
Let me go back to the introductory language in 5B1.
Yes, sir.
Which says an insurer or insurer is not required to pay a claim or charge.
Yes, sir.
What is a claim or charge? How do you define those two terms in this context?
In this case, a claim is all of the bills that were submitted by Chiropractic 1 for a particular patient.
And where does that definition come from?
It's not specifically defined, but here's how you arrive at that definition. By the way, the charges are all the charges within the claim, to fully answer your question. I think the way you arrive at that definition is I agree you have to look at paragraph 5D. And paragraph 5D talks about when particular statements and bills are not payable. And it leads off by saying all statements and bills for medical services rendered by any physician or other person shall be submitted to an insurer on a properly completed CMS form. So 5D deals with specific statements and bills.
So you're saying the form is basic, whatever is included on that form is the claim?
Well, no, what's included, when a form comes in for a particular date, or say 2 or 3 dates of service, that's a statement or a bill. Okay? When multiple bills are submitted, those comprise the claim.
Okay, well, if claim is all-encompassing, what's the relevance of the or charges part in both 5B1 and in sub C? They both say is not required to pay a claim or charges to any person relating to the claim or charges. We're required to read statutes, so no part of it is deemed to be of no effect at all. If claim is that all-encompassing, what does or charges add?
Well, I think it adds a subset of clarity within claim. In other words, when we did the 97140...
So it's not to pay a claim including charges, it's to pay a claim or charges, so that wouldn't tend to indicate that it is a subset. That would tend to indicate it is some separate definition.
Yeah, I think this was the legislature trying to be broad. I don't think this was the legislature trying to narrow claim. I think they threw claim and charges, recognizing claim or charges, recognizing that there's a claim, and within the claim there's charges. And they want to make it clear that they're trying to catch everything here. That's what I think happened. But to get back to it, 5D deals with specific statements or bills, and it says if they're not properly completed, that statement or bill, the insurer is not put on notice of, and the insurer doesn't have to pay it. There's no knowingly requirement for that. So if the bill is just not properly completed and there's no fraud, then the insurance company can say, hey, this is not properly completed, we don't owe this bill.
But that's correctable. Right? They could submit a new bill that filled the
met
gap.
requirements.
I think so, yes.
But if it's knowingly, it's not correctable. is
That's
what you're
right,
saying.
because you crossed into, we're using the term fraud loosely here. I think everybody knows that knowingly is a defined term and doesn't require fraudulent intent under 627-732-10, but we can talk about it in fraud for ease of discussion. When you cross that bridge and you move into knowing misconduct, you have put yourself into 5B1C and you've put your entire claim at jeopardy.
Now, the issue of whether it applies to other doctors, either A, in the group, or B, other treaters outside. What's your position on that?
It does not apply to other treaters outside. I think clearly.
Those would clearly be separate claims and charges.
Absolutely.
Okay.
Yeah.
Because unless you could show that they knowingly participated somehow, those would not be proper for you to say, well, we're just going to deny the claim.
That's correct, and that's made clear by to any person who knowingly makes a false or misleading statement. The other
So
doctors would
is
not
the
fall
person
within the
in this case each individual chiropractor, or is Chiropractic 1 a person?
Chiropractic 1 is a person. As you know, I think it's the definitions in 1.01 of Florida statutes defines person as corporations and every business entity in the world. Chiropractic 1 is the person. Chiropractic 1 is the entity or the person that issued the bills. In this case, it's Chiropractic 1's claim, and it's Chiropractic 1 that lost its claim by engaging in repeated, systematic, and knowing misconduct in this case.
So getting back to my prior question, if everything was done legitimately, let's say for a year, and numerous claims were submitted, numerous bills were submitted, and they were all legitimate, and then the last one comes along and it's fraudulent. You're saying that you can go back and void all and say that based on the fraud of this very last bill, that the prior bills that we paid, we can go back and recollect our money based on the fraud of the last bill.
Well, that gives rise to, does this situation that you just explained fit within an unjust enrichment or a fraud cause of action that would allow you to do that?
But then we're talking about a timing element, because you're saying that once the fraud of one claim and then subsequent claims are submitted, and they're legitimate, those subsequent claims are knocked out. It would seem to make sense that if you're going to say that, then your position would be that anything we paid on the claims before that were legitimate, we could go back and rescind and get our money back for that.
I feel like that's likely the case. I want to be clear, that's not an issue in this case.
Well, I know, but
And so-
if we're going to interpret the statute the way you want us to, then in any single claim that's fraudulent knocks everything out. I mean, you would be able to go back and claim that we wrongfully paid or improperly paid these first bills, and we want our money back for that too.
Again, I think that affirmative relief is what you're talking about for a fraud claim. That's certainly a possibility. That's not an issue here.
I know.
But let me say
It wouldn't
this.
have to be fraud by the chiropractor. It could be if the billing clerk fraudulently did it, that would be covered too, right? Anybody on behalf of the entity.
The entity, which is Chiropractic 1, that's the entity that's submitting the bill, and that's the entity that's looking to get paid. That's the entity under which the services were performed, and that's the entity under which there will be payment made if appropriate. And Your Honor, you raise a good point about the timing. We all deal in the practicalities of these situations. Nobody knows when fraud is going to arise. I can tell you that what you've described, the ability to go back and file a claim if the fraud came later, I think is consistent with the legislature's policy of giving insurers, PIP insurers, the tools to fight the rampant PIP fraud in this state. And the very, very simple answer is, don't do it, providers. Don't commit fraud. Don't knowingly submit false and misleading statements. Treat your patients and bill appropriately for it.
So what would be the relief of the provider who thought that State Farm was being outrageously picky on these things? And if State Farm concludes that there was a knowing submission of improper information or incorrect information, what's the relief that the provider gets?
If there's a bill not paid, the provider files a PIP suit.
In county court?
I'm sorry?
In county court?
Yes, if that's what the issue is a county court jurisdictional amount. In Judge Sawaya's hypothetical, if some affirmative relief was brought as a result of that, the provider defends it and serves proposals for settlement and does whatever it needs to do to
Mr. Azori,
protect its interests.
is there any legislative history that would support your view of these statutes?
Other than the strong statements about the anti-fraud provisions, which are cited in our brief,
Yeah.
I am not aware of any specific legislative history describing 5B1C and what it does. I can tell you, in response to your question to Ms. Gruner about has the legislature dealt with this going forward, I think at least everybody on this side of the room knows there's a new PIP statute with a lot of changes to it. They have left 5B1C intact exactly the way it is now.
It has not been modified.
It has not been modified. And again, I think it's for the purpose of allowing insurers to do what they have been charged by the legislature to do. First of all, they have to set up a special investigative unit to investigate these things. They're legislatively mandated to do it. And then in the 2001 and 2003 acts that added these anti-fraud provisions, 2003 was 5B1C, strong statements specifically adopting the grand jury's recommendations on its findings of PIP fraud, and it says right in there, take a stronger stance against paying fraudulent claims. Investigate these and don't pay them. I'm paraphrasing. That's what it says. How is an insurance company, if the legislature put that charge on an insurance company and says you must go do this, how could it possibly be interpreted that 5B1C doesn't give them the tool to carry out that mandate? And if you don't interpret it in this way, then what's going to happen is, as I think Judge Monaco, you gave some hypotheticals about a large amount of charges being fraudulent and one or two being good. What's going to keep a provider from doing that if you don't interpret 5B1C in the manner that we're...
Yeah, but the other side of that is what's going to keep State Farm from rejecting all claims if they have even the slightest inkling that there might be one fraudulent submission?
And here's the answer to that. One, there's an avalanche and a tsunami of fraud. There's a lot of practicalities that go into this. State Farm doesn't have time to go picking on legitimate providers who may make a mistake here and there. They focus on cases like this one where there was systematic, continuous fraud.
So we're relying on the tsunami of fraud in order to keep State Farm in line?
That's part of it. Here's the other part. There's a practicality. Why are they going to spend their time chasing somebody who made a mistake when they've got cases like this that are so obvious?
I know that's practical, but I'd really like to see something like in writing.
Well, here's the other part of it, Judge. You raised it before. They have a remedy. If State Farm picks on somebody improperly and says you knowingly did this and it's one charge out of 100 and they're saying you're committing fraud, file your PIP suit. If they win, they'll get paid all the big fees that they get. They'll get paid. There'll be people lining up to take that PIP suit in an egregious situation. And that's going on every day in these county courts. They have a remedy to address that situation. It's completely handled. That's my answer to your question.
That's actually much more satisfying than the avalanche.
Okay. Well, I'm glad I got there eventually. Unless you have any other questions from me, I could go through some more of the evidence of fraud if you're concerned about that. But
Thank you, Counsel.
thank you.
I got to say, this is a really interesting suit.
Why don't you address his main point, which is that if fraud is going to stop, that the statute should be interpreted to say that if you knowingly commit a fraud and knowingly make a false statement in a claim, that knocks all your claims out. Because if we say that, well, that you pick and choose, they pay the legitimate claims but don't pay the fraudulent claims, what incentive is that for aberrant medical care providers not to commit fraud anymore? They'll say, well, maybe they won't catch this one, or maybe they will, but we'll take our chances, and we know we're going to get paid for the legitimate claims. So what are we losing? What harm do we suffer?
I think what you've got to look at is exactly what Mr. Hazuri's statement is, how this case started. This case started because William Talley, the adjuster, the SIU fraud adjuster in this case, told Dr. Bucko at Chiropractic 1, you can't use this code, CPT code, with this code. They did not depose ever the doctor that did the treatment. They only deposed Dr. Bucko and only gave Dr. Bucko hypotheticals. Assume this to be true, assume that to be true. Objections were stated, and still, that's their bootstrap argument.
But get to the larger issue here, which is that obviously the statute is intended to prevent PIP fraud.
Absolutely.
And how is that going to occur? And how is it going to be a disincentive to medical care providers to stop the fraudulent conduct, if we're going to say, well, all your legitimate bills get paid, but the ones you get caught for that are knowingly false, we'll just say you don't get paid for those.
One of the most important things in the PIP statute is to pay claims. Pay them swiftly and pay them accurately.
Right, but
it's not
that's
to see
because
that
it's a
insurance
no-fault
companies
system.
don't get taken. It's to pay your claims. See that your insureds get treatment if they are hurt. Not for people like William Talley to play doctor and say that you can't use this CPT code with that CPT code, now I've got a bootstrap argument. That bootstrap argument is that every time you use those two codes in conjunction, it was knowingly fraudulent. You don't have a patient statement. You don't have the doctor.
Well,
that
you're back
rendered
to your
it.
argument about whether there was fraud.
Yeah, I mean,
we're well beyond that argument. It seems to me.
I want to know, how is the intention of the legislature fulfilled by enactment of the statute if we say, well, if you get caught with a fraudulent claim, you just, that particular bill you won't get paid for, but if you keep submitting bills and they're legitimate, well then, those will get paid. And the medical care providers, some will just simply say, we'll just take our chances. We'll roll the dice and we'll submit some that are legitimate and some that aren't. And if we get caught, well, we'll just lose the ones that are not legitimate and that are fraudulent.
Judge, with all
that's not a disincentive to commit fraud, is it?
No, sir. With all due respect, though, you're always going to have people that are going to test the system.
Oh,
This
that's
is
right.
not that
The
case.
system is going to be gained no matter, there's no way that the legislature is going to completely knock out PIP fraud. This is not going to happen. But
Absolutely.
what they can do is try and reduce it as much as they possibly can.
But you don't use the largest insurer in the state to cherry pick. You can't use this CPT code with this CPT code.
All right, well,
That's
back
what
to-
makes it
all right,
fraud.
well.
You can't use that.
Thank counsel, your time's expired. Well argued on both
Yeah,
sides.
very, very well presented. Thank you.
The next